So I want to just start out by acknowledging that we are hosting this event. Many of us are across the country, but that Osgoode's hosting this event from the traditional territory of the Huron-Wendat, Haudenosaunee, and Anishinaabe nations, and in the Dish-One-Spoon territory, a treaty that speaks about caring for and sharing the land. And I think, at this time of year, we get such an important reminder of how the land also cares for us as we see these signs of spring emerge, depending what part of the country you're in. Those might be a little bit more or less, but it's a good reminder of that relationship. And that relationship is also at the core of some of the issues that are really part of this litigation we're going to talk about today. So I'm going to just introduce who we're hearing from today. We're briefly going to hear from Professor Lawrence to make sure we're all on the same page about what it is we're talking about when we talk about advanced costs. And yes, it's true. We don't feel that springy this morning in Toronto, but there have been moments in the last few days. So Professor Lawrence is going to give us that bit of background to get us all onto the same page. And then we're going to hear from Avnish Nanda, Karey Brooks, and Professor Dayna Scott. So I'll briefly introduce all three of you and then pass it over to Professor Lawrence. So Avnish Nanda is a litigator with Nanda and Company who practices in Alberta and British Columbia, specializing in civil, commercial, and public law litigation, acting for individuals, corporations, and nonprofits and First Nations governments. He was drawn to the law out of interest and involvement in social justice activism, which he's continued through his legal practice, frequently acting for parties advancing civil liberties, human rights, and Indigenous self-determination. Avnish has extensive courtroom experience, from conducting trials to prosecuting and defending complex multi-day motions and applications hearings, and is also a sessional instructor in constitutional and environmental law at the University of Alberta's Faculty of Law, teaching seminars on the scope of the Charter of Rights and Freedoms and the environmental realm. Thank you so much for joining us today. Karey Brooks, Queen's Counsel, is a principal with JFK Law in British Columbia. She primarily acts for First Nations and First Nations organizations in court and negotiations with government and industry on matters relating to Aboriginal rights and title, consultation, regulatory matters, including environmental assessments, and general governance matters, including status and membership issues. Karey also has experience in other public law related work, including with respect to charter rights litigation and public inquiries. And Karey has been counsel on a number of leading Aboriginal law cases that many of you will be familiar with from already in 1L, and including on the case we're going to hear about today. Professor Dayna Scott is our colleague here at Osgoode, who also co-directs the Environmental Justice and Sustainability Clinic with me. Some of you will have already met her in that capacity and will know her, but for others, Professor Scott teaches in the areas of environmental law and is cross-appointed with the Faculty of Urban Environmental Change. And Professor Scott works closely, and I think will tell us a little bit about her work with communities for whom the ability to finance litigation is a major part of the potential to address ongoing and serious environmental justice issues. And so this case has really important implications for her research and also the work that we do at the clinic. So welcome to all of you. Thank you so much for being here and joining us. And with that, I'll pass it over to you, Professor Lawrence.
Okay, thank you, Estair, and thanks everyone for coming. So I've just dropped into the chat a link to see if you guys want it. There is a handout for this session. So I think that's the best way to try to give it out in the session. So all I'm going to do today is just provide this brief overview. And I nominated myself to do this because I myself am a bit of a newcomer to the issue of advanced costs, so it's going to be very brief. So the line of cases that we're talking about today asks really for, I think, how our understanding of access to justice considerations might temper what the Supreme Court has called the harshness of traditional costs rules. So traditionally, costs are said to follow the results, so that offering costs prior to a determination on the merits has seemed to courts, many of the courts that were trying to decide the cases that we're going to talk about today, has seemed to them to maybe prejudge the issues in the case, the legal issues. So the idea of interim costs or advance costs really urges us to try to decouple costs from the final result and instead try to even out the access to justice playing field. So the point is to ensure, as the Supreme Court says, that ordinary citizens have access to the justice system when they seek to resolve matters of consequence to the community as a whole. So the line of cases that we're going to talk about today begins in a 2003 case called Okanagan, where the Supreme Court of Canada brings this notion of advance or interim costs award to public interest litigants. Okanagan involved 4 bands who were alleged to have breached the Forest Practices Code in BC through logging activities. And the bands claimed that they had Aboriginal title to the lands in question and were entitled to log them, but they didn't have money to fund protracted litigation. And the BC Court of Appeal in this case held that the court did have the discretionary power to award such interim or advance costs. And the Supreme Court agreed and set out a test which could be applied in applications for advance cost award. And that test has a number of different elements. And the cases since Okanagan have kind of taken up these elements for further clarification and development. So the requirements revolve around, I think, 3 things. First, the claim itself has to be in the public interest and meritorious, so that it would somehow be contrary to the interests of justice for the opportunity to pursue the case to be lost simply because of lack of funds. And then this measure is only to be applied in rare and special circumstances. And then for the third requirement, we kind of move off the case and onto the litigant. And the litigant has to be genuinely unable to pay and have no other realistic options for bringing these issues to trial. So this framework was tested at the Supreme Court in Little Sisters 2. So many of you will be familiar with Little Sisters number 1. The path-breaking challenge on 2B and Section 15 grounds in 2001. The Little Sisters returned to the Supreme Court on similar issues in 2007, because as you may remember, they received only declaratory relief in the 2001 case. And in rejecting their advance costs application, the Supreme Court helpfully said that they had met none of the parts of the test from Okanagan. In Quran, which was litigated by our very own Professor Berger, who I think is here. In this case, this was about the right to have one's trial in French, but in Alberta. So in this case, the litigant ran out of money 18 weeks into the trial. He had raised funds from French language organizations. He had court challenges program funding, but the court challenges program shut down mid-trial. So the Supreme Court said that when this happened, the provincial court found itself holding a tiger by the tail. Holding a tiger by the tail is supposedly a bad idea because you can't really let go or things will go really badly for you. So in this case, the problem is not really for the court. They're not going to get bit by the tiger. It's for justice. The unexpected length of the trial had exhausted Mr. Caron's financial resources, but substantial public time as well as court time had already been expended. And the Crown had just put in what was described as a mountain of historical evidence. So without a solution on the funding question, this genuinely important constitutional issue was going to be litigated and probably appealed on what would be a very uneven record. So there was also a nice jurisdictional question in this case about whether a provincial court could make an interim costs order, and if not, whether a superior court could do so to help out, all of which the Supreme Court said was fine. So the next Supreme Court case in this line of cases is Anderson or Beaver Lake Cree Nation, which we have brought in expert speakers to talk to you about. So ideally you have some sense of the framing now of where advance costs have come from, advance costs at least for public interest litigants. And now we can think about what Anderson has brought to the table. So let me turn it over to Karey Brooks. Thanks, Karey.
Thanks, Sonia. That was such a great introduction. You did a lot of the heavy lifting there, so that's much appreciated. First, let me just thank you for having me. I'm really just thrilled to have this conversation with all of you today, and thank you for your interest in this topic and in this case and for attending. And of course, I'm thrilled to be presenting alongside with my other panel speakers. Nice to see you both on this virtual platform. I'm coming to you from the unceded lands of the Coast Salish people on the West Coast in Vancouver. And I think in making those land acknowledgements, it's always important to recognize that as members of the legal profession, or soon to be, that we are very well positioned to advance the legal and moral imperative of reconciliation. And this presentation deeply engages principles of reconciliation. And I was just thinking about this very momentarily. So if I had given myself a little more time to prepare this in advance, I'd have something more eloquent to say about this. But I was thinking about my personal commitment to reconciliation and how that shows up for me as legal counsel for Indigenous clients, and the relationship that we build with our clients. And I was thinking about that because over the past week, I just went back to Beaver Lake Cree's community, and I was with the clients, and I had some of the members of my team there. And so we were talking a lot about our obligation and responsibility to be in relationship with our clients. And I just think that's very distinct from other clients that you might work with. And there is a special obligation to think really intentionally about how you're in that relationship and advancing reconciliation. And I'll try to comment more on that as I talk to you a bit about Beaver Lake Cree's experience in bringing its treaty infringement claim, and how I see the special role of counsel in acting for an impoverished First Nation community. But what I thought I'd do, because I think the sort of doctrinal aspects of the case, well, they weren't very clearly defined in respect of impecuniosity before the Supreme Court of Canada. With the Supreme Court of Canada's decision, we can see that they're really not that complicated. You can read the decision and see that the Supreme Court laid out a very clear roadmap, both for applicants and for the courts, about what's required to prove impecuniosity and what factors should be taken into account. So I thought it might be more interesting for you if I shared a bit about behind the scenes work that goes into running a complex treaty infringement case, the costs involved, and the decision of Beaver Lake Cree to bring the advanced cost application, and some of the challenges that we faced in collecting evidence, and just other aspects of managing the case from my perspective as legal counsel. So what I'm going to do is just tell you a little bit about the main litigation and some of the challenges that Beaver Lake faces in bringing a complex case like it has, and what went into bringing the advanced cost application. And then I will talk a little bit about the decision and what some of the principles are that I think are really great from the decision, and where I thought the decision might have fallen a bit short. Before I get into that, though, I do just want to acknowledge and recognize Professor Berger, who I reached out to when I was preparing for the oral hearing before the Supreme Court. And I reached out to him because I was watching the Carone decision, or the hearings, pardon me, which of course you'll know that you can watch. You can watch the SCC hearings; they're all archived. So I was watching that to get try to get a feel for what was pressing on the court's mind at that time. And I saw Professor Berger give submissions. I think it was on behalf of the BC Civil Liberties Association, but I was so taken with his delivery and presentation, and he actually addressed the issue of impecuniosity and made the argument that applicants should not have to destitute themselves to bring these publicly important cases. So I reached out to him for some advice and tips, and he was enormously generous in brainstorming and workshopping with me how to express what the test should be, and really work through what some of the concerns of the court might be. And I think it helped the submission that I ultimately gave enormously. So I really thank him, and just thought I'd let you know about the great work that that your professors are doing to help legal counsel in bringing these matters before the courts. So Beaver Lake's main litigation, it brought the case in 2008. That's when the initial pleading was filed, and the claim was initially filed by another law firm. It wasn't our firm, it was Woodward and Company. And at the time, it was a really novel case. It was really creative, it was cutting edge. It claimed that the treaty promised First Nation signatories that they could maintain their way of life and practice their culture without significant interference. And it really drew on one sentence from a case called Mikisew in 2005, which some of you may know about. That's the duty to consult when you're taking up under treaty. And there the court had said, Justice Binney had said that there may come, well, each taking up is not an infringement, which is what the Indigenous and the First Nation had argued in the Indigenous groups, because the treaty allows for taking up. There may come a time when there is no meaningful right, and that could ground an infringement action. And so drawing on that one line from Mikisew, Beaver Lake filed its claim. And so its main claim is about the cumulative impact of all of the taking ups in Beaver Lake's traditional territory. So it's not just about one project. It claims that when the Crown is taking up land, which it's allowed to do under the treaty, that it has an obligation to ensure that there's an adequate quality and quantity of land left to meaningfully exercise treaty rights. And it said the Crown failed to do that. And instead it's allowed all sorts of development, oil and gas development, agriculture, forestry, settlement, roads, seismic lines. And it did that without considering the impact of the collective impact of those activities on the rights of Beaver Lake. And so Beaver Lake has now reached a tipping point and its rights are at risk of extinguishment. So it's a really complex claim. The legal issues are complicated, the factual issues are complicated. It involves treaty interpretation and then an understanding of what has happened on the landscape over the past 40 years. What has the impact of that been on members' ability to exercise their treaty rights? And these types of claims, Aboriginal right claims and these treaty rights claims, they take years to prosecute. They cost millions and millions of dollars. And for the most part, most First Nations just simply don't have the funding to be able to launch these claims. And here we're dealing with a case of extinguishment of rights. So really serious risk of extinguishment against the inability to enforce those rights. So there's huge access to justice problems here. Immediately after filing the claim, Beaver Lake engaged the services of a company called, or an organization I say, called Raven, and to assist it with fundraising. Beaver Lake knew after it filed its claim that it wouldn't have the resources to carry the litigation through to trial. So it immediately started fundraising. Raven is an organization that fundraises. It actually Beaver Lake was the first client it had, but it's since fundraised for many other First Nations who are unable to pay for the costs of enforcing their rights. But there are members of Beaver Lake who helped Raven in all sorts of ways to raise awareness about the case, both locally, nationally, internationally, went on speaking tours. Beaver Lake was profiled in Naomi Klein's This Changes Everything documentary. It was one of the communities that she focused on in looking at the impacts of climate change. And Beaver Lake was really successful in its fundraising. There was enormous support for Beaver Lake's claim. Even the UK banks provided money. There was even a UK law firm that was willing to provide pro bono services, and that resulted in an application before the Corp, which was denied because they didn't have a right of audience. But Beaver Lake has made significant efforts to try to raise money for its litigation through third-party sources, and ultimately has been very successful in that. It's raised over $1 million to support its legal fees. But as I will get to, as you can imagine, the money starts to, there is donor fatigue that starts to happen, particularly when the case isn't really moving ahead and people wonder if it's ever going to get to trial. It discourages donors. So eventually the donor money dried up. So, and I think it's important to understand, for the purpose of this advanced cost hearing and what the court, some of the issues that the courts was dealing with when they look at a First Nation government as an applicant and understand what what happens when a First Nation government has some non-governmental revenue? And can it still qualify for advanced costs? And I'll touch on how the courts dealt with that. But I think what's important for you to understand is that First Nations operate under really serious financial constraints. They receive most First Nations receive government funding for their funding and for their programs and services, but they're notoriously underfunded. Some First Nations can receive additional, what they call like own source revenue, so non-governmental revenue, and that can come from various sources. For Beaver Lake, it comes through what's called impact benefit agreements, which are agreements with industry, so the players who are taking up the land in their traditional territory, which has resulted in the infringement of their treaty rights. That forms the base of the claim, but they enter into agreements and they get accommodation funding from them. And that's always, as you can imagine, a deep source of distress for the nation, who they don't have any other source of revenue, but they have to enter into these agreements to get revenue, and yet the agreements facilitate the development on their land. But even that money is still subject to restrictions. The industry, when they're giving the money to the First Nation, they make it clear what the money can be spent on. It cannot be spent on litigation. It must be spent on community purposes. Some of the money is directed specifically for consultation. And so for Beaver Lake, they had money from industry, that some was for consultation and some was to be put to community purposes. And just to give you a sense of the numbers, Beaver Lake at the time of the hearing had about 2 million in trust from the industry for community purposes, and they had about $1 million that was being used every year for consultation. There's one other source of money that Beaver Lake had, which was money from royalties for oil and gas development on reserve. And that's held in trust by the federal government. It requires ministerial approval to access. So, and at that time, again, just to give you a sense of the numbers here, that number was at 2 million. And Beaver Lake was withdrawing that money, the capital from that account, to use to supplement the program and services deficiencies. So every year they would be short money to pay people to administer the programs or to make improvements or repairs to infrastructure, and they'd have to draw on their capital to do those things. I think it's also really important to think, when you think about this community and the constraints on its spending and the obligation to act in the interest of, to act as a fiduciary to its members and to just practice good governance, to think about what it would be like for a government to be effectively managing a town of people of about 500 in a very remote area. Most 70% of the people in this town are unemployed. They rely very heavily on the services and programs that the nation provides. And there is a lot of suffering. There's a lot of issues with addiction issues. The suicide rates are wholly disproportionate. And when the community members, they have no other place to seek services and programs. So this is a little different than an urban First Nation who might be able to access provincial services. There really is nowhere else for the members to go. When they go to town, which is Lac La Biche, a lot of the members report experiencing discrimination and racism. And so the way that it was described to me was that a lot of the members were essentially bushed. They didn't leave the reserve. So those are all really important contextual factors when thinking about what it means to be impoverished. And when the nation has these limited resources that it has, is it reasonable that it be diverting that money to enforcing complex, really expensive litigation that we estimated will cost at least $5 million. And so it would effectively have to deplete all of its resources on this litigation. So just think about the impact of that on this community if it was to do that. So the history of the litigation is that for the first, it's been many, many years over, and in the first 5 years of bringing this claim, as I mentioned, it was novel and complex. The Crown brought multiple motions to strike, which went to the appeal courts. It took 5 years to resolve the strike motions. And the arguments, really were in large part that this claim is too big. It's too big, it's too unwieldy, and to which the Court of Appeals said that just because the extent of the liability is significant for the Crown doesn't mean that it's not justiciable. But again, it speaks to this point where the Crown recognizes that these cases are enormously costly. And the 5 years, just again, to give you a sense of the numbers we're talking about, to defend those applications cost the nation $1.3 million. And that was largely paid through fundraising. By the time our firm took carriage of the file, that strike issue had resolved. It was 2014. And so for the next 3 years, we took a number of steps to advance the litigation. We answered thousands of particulars, retained a number of experts to do some preliminary assessments and reports. And then we did huge document disclosure, which is a big deal in these cases. But ultimately, the client was unable to contribute. I can disclose all this because it's all on the record. Unable to contribute any more than $150,000 a year. They were fundraising on the side. So usually the nation was able to contribute about $300,000 to the case a year. And again, just to put that in perspective, that's about, if one lawyer was working on the file, that would be about 15 to 20 weeks of work from one lawyer a year. Or potentially the cost of an expert report and a half. Some of these expert reports are $200,000-$300,000. So, and this is as I said, this case really requires at least sort of 3 to 4 lawyers working on the file pretty steadily, obviously right before the year before trial, full time, and then during trial. What we see in these complex cases, and we have now a real world example with a case called Blueberry, which is dealing with the same claim. And Blueberry filed its lawsuit right after the strike motions had resolved on Beaver Lake's claim, and they filed the identical cumulative effects claim. And Blueberry was able to fund the litigation properly, and they got to trial in 5 years, and their litigation cost millions. And they had, at the time of trial, about 8 lawyers that were working on the file. So Beaver Lake has been having to do their work with one lawyer kind of half time, a quarter time. So it's just not enough resources to push the file ahead at the rate required. In the meantime, the cumulative effects are worsening. So we had a really hard conversation with the client about bringing an advanced cost application. And we told the client, you will have to bear your financial soul. And it's going to be hard. It's going to be really hard because it's going to be tough on the community to disclose the poverty and the harm that faces the community. So we spent, but ultimately the community felt like it had no choice. It doesn't have the funds to do this litigation, and its treaty rights are at risk of extinguishment. So it decided to take the leap and bring this advanced cost motion. And I just want to stress that, because I think we read these decisions and may not really appreciate like just how difficult they are on the human side to bring these types of applications forward, and the pain that goes along with it. We spent a lot of time in the community. I went up there myself with a colleague for a couple of weeks, and we ended up coming away with about 12 with elder evidence from about 12 members and evidence from the administration. We focused a lot on the merits because Sonia laid the test out. You have to establish it's meritorious. We, of course, assumed that the federal government and Alberta would be resisting every aspect of the test. And so we really hammered the merits and then also addressed what the financial resources of the nation were, and that they were an impoverished community. We relied heavily on a decision called Keewatin, which is the Grassy Narrow case that was also funded through an advanced cost order. and so was Chilcotin. So the two kind of big decisions, one on treaty rights and one on Aboriginal title, were both funded by advanced cost orders. It's just, it's almost impossible for a First Nation government to fund these types of cases. And yet look at the benefit that all Canadians have in having these important issues answered. But Keewatin was a similarly situated First Nation that had a trust fund, and it was, members were actually we don't know the amount of the capital in its trust fund, but I always was pointing out that the interest it generated was about $500,000 to $600,000 a year, whereas the interest that Beaver Lake's case generated was $50,000 a year. And the court there was looking only at the interest. No one even looked at the capital. And again, you can probably pick up, this is a bit of a sore spot for me, because the Crowns and the court are looking at the capital, saying to Beaver Lake, exhaust your capital, which is arguably not a prudent thing for a government to do. But in any event, in Keewatin, the court decided that although the interest generated from the capital trust was sufficient to cover the cost of litigation, it was unreasonable to ask the nation to spend the money on litigation when it needed that money for basic needs. So we have this test of necessity and basic needs. And so we argued, relying heavily on Keewatin before the case management judge, that Beaver Lake was an impoverished community, that it had some resources in addition to federal funding, but that it needed those resources to cover the federal funding shortfalls, that it was spending the money on that, it was spending the money on consultation, and that it was saving this $2 million in trust so that it could grow the capital, grow the interest, and use the interest to supplement deficiencies in programming. Now, Canada and Alberta had argued Beaver Lake should be required to exhaust all its resources, that it should use its consultation money, that it should sell. Just to show you, in my view, how oppressive it was, that it had a minority interest with 6 other First Nations in some oil services companies, because the companies provided jobs for the members, and it produced no dividends. But the Crowns argued that they should sell those interests to their companies, and they're not liquid, they couldn't sell them, and the court agreed with us. But that provided employment. That's why they are partners in these companies. But they also said that they should ask the minister to empty their Ottawa Trust account, which they used to cover the operational shortfalls annually. And until they had done all that, it was the argument that they couldn't qualify for advanced cost. So the case management judge, she found that Beaver Lake, she made unequivocal findings that Beaver Lake was in undeniable poverty. And she went through detail some of the resources, all the resources that Beaver Lake had, and that Canada Alberta claimed should be used for the litigation. But she ultimately found that it would be manifestly unjust to require Beaver Lake to use all those resources. And so she ordered that Beaver Lake continue to pay $300,000 toward the litigation, but that Canada Alberta also contribute $300,000. So she put an annual cap on it. And so Canada Alberta appealed that. So they were required to pay just $300,000 a year to get this done, but they appealed it and said that it was effectively the wrong test, because Beaver Lake had resources and you couldn't qualify for advanced cost if you had any resources. So at the Court of Appeal, it was really intense, and I really felt like I was in a firing squad. The Court of Appeal was not happy with her decision or our arguments, and said that and effectively expressed a test of any funds available test, and said that you couldn't have funds that you said were needed for what the court there described as improvements, so better housing or improvements to infrastructure, that those were not basic needs. So what we had is a test really that amounted, after the Court of Appeal in Alberta, any funds test. If you have any funds available, you can't qualify, and that the funds that you have have to be directed to basic necessities, very narrowly defined. It was really difficult to know, you know, if you had basically had clothes on, your basic needs were met. It was a very narrow understanding from of basic needs. So Beaver Lake sought leave and was granted that, obviously, and then we come to the Supreme Court decision, and really here, and I'm just mindful of my time, so I'll just focus on a few things from this case. But really, the key holding here was that the court resolved this big issue that was in dispute about what happens when a First Nation has some resources. Can they still qualify for advanced costs? And the Supreme Court said that they could, but in bringing the application, the applicant has to adduce evidence, not only of identifying the pressing needs of the government, of the First Nation, which is what the court here had agreed Beaver Lake had done. It had identified those pressing needs, and that the finding of the case management judge that Beaver Lake was in undeniable poverty was founded on the record. So we have, at least, I hope, going forward, an agreement that that finding was sound, but that you have to identify the costs of meeting those needs, and that Beaver Lake hadn't done that. So so Beaver Lake is, and then you look at the financial resources that the First Nation has, its assets, its liabilities, income, expenses, any restrictions on that. And then you have to compare and you see what's left over, if anything, and then you compare the estimated cost of litigation with any surplus resources. So that's, the court laid out this kind of 4-part test for impecuniosity and what the court needs to review in looking at the evidence. And ultimately, what I think is the good things about this test is that I think the court also said, in having regard to the evidence about the First Nations pressing needs and how it's managing its resources to meet those pressing needs, must take into account the First Nation perspective on governance and its own priorities. So that's was a really great part of the decision, because the Crown had argued, and so did the Alberta Court of Appeal, find that it was only an objective test, that the subjective perspectives of the First Nation didn't come into play. So that was important. And also the court recognized that pressing needs aren't bare necessities, that the court said, in keeping with the imperative of reconciliation, they have to be understood from the perspective of the First Nation government, and it may include things to promote cultural security in the community, for example. So that's another important aspect of the decision. And finally, the court also said that judicial notice could be taken of systemic and background factors that affect Indigenous communities and translate into lower education, lower incomes, higher unemployment, and those things will all affect the First Nations spending priorities. So what do I think is missing from the decision? I think what's missing is, I think the test, I understand what, the test, I think it's probably fair. I think that the thing that's missing is the cost to bring these applications are in themselves extraordinary. And fortunately, the court awarded Beaver Lake solicitor client costs so that it can get get some of this money back, so that it will defray the cost of having to bring this application again. But it's hard to explain this in a way that is appropriately sensitive to giving dignity to the community. But when the community is facing the type of challenges that Beaver Lake Cree Nation is facing, it's really hard to expect that they would be able to just produce a strategic plan or this list of priorities about how they're going to deal with the suicide crisis that faces the nation. I mean, the nation is in crisis management, and it's just putting out fires. And I think it's a little, it's a high onus now for First Nations to have to cost out all of these needs and get appraisals done. And the court did provide that there can be some nations that would just not be, they would not be even able to do that. But Beaver Lake was one of those nations. Like, it's hard to imagine, like Beaver, it was manifest how impoverished the community was, and that they just wouldn't have the type of, like, we have to now create that evidence. So we will be engaging with consultants to go into the community and meet with everybody. But the idea that they would have this big visions board and statement about, clean drinking water, like reduce the suicides in our community, like, it's just really not realistic. And really, I think, a bit insensitive to the deep challenges and poverty that the community faces. But having said that, we see what the court needs. We will be putting together that evidence. And frankly, I feel very confident that the evidence is so overwhelming that Beaver Lake will establish without any difficulty the test for impecuniosity. So anyway, I'm sure I just ran over all my time, and I'm sorry to my other panelists for that. I'll stop talking now.
Thank you so much, Karey. That was really insightful and helpful to really understand what the community went through in all of this. I'm going to hand it over to you, Avnish, to tell us about kind of broader implications of this kind of litigation.
For sure. First of all, I just want to acknowledge that I am on Treaty 6 territory. I'm speaking from Edmonton, and the Treaty 6 territory is where the Beaver Lake is also located, the Beaver Lake Cree Nation. It's important for me to mention that because of what Karey has highlighted, that there are particular issues within this territory, but all over Canada, I think, when it comes to colonization and its effects and how it impacts Indigenous folks, but particularly young Indigenous folks that and people I work with day to day on a variety of issues. Reconciliation is not limited from a nation to nation perspective, but also kind of day to day how individuals who are status or non-status but are Indigenous deal with the state, deal with others, and try to kind of assert their dignity and move through society in a way that I think is fair and equitable. And I'll get to that. But before I turn to my submission, I just want to say that what Karey did was remarkable. I actually was a young lawyer in Edmonton, and I attended the advanced cost application for Justice Brown. And then I watched a bit of the Court of Appeal hearing. And then I had the opportunity to present at the SCC on this one. And for Karey to go and get the initial order and then face that particular panel at the Court of Appeal and endure and survive it, not a great outcome, but take it to the Supreme Court of Canada with this composition and get a 7-0 judgment, but also get solicitor client costs throughout. That is remarkable. And I just think that's a testament to Karey and her hard work, and just it's something that should be celebrated and noted. Karey also mentioned something that's important, that there's doctrine and then there's context and reality. I think that is an important thing that we need to discuss when it comes to advanced costs, public interest litigation, particularly in the spirit of reconciliation in this realm. So when Karey says that there is, a bit of a, not a fantasy, but this framework, doesn't reflect the reality of many marginalized, vulnerable folks, I echo that. I just think the doctrine doesn't acknowledge circumstances like there's a few cases that I've been working on in the last 3 years here in Alberta, and where, I think if I brought an advanced cost application, I would be successful, but it's not practical from an urgency perspective, from kind of the court's perspective in terms of timing and things of that nature. I'll give you an example. I'm working on a case that involves former children in care who've aged out. Initially, they were accessing benefits. The government truncated the benefits and the impact on these young, extremely vulnerable young people who've been in care is significant. And in the case of the clients that I represent, and most people who belong to this program, it's about 2,000 people, hundreds are added each month. Vast majority are Indigenous folks, usually Indigenous women, often with dependents between ages of 18 and 24. And I got this case about 3 months before the program is supposed to be cut, and immediate impacts to my clients, like immediate impacts to the extent of, returning to sex work when these young women don't want to return to sex work. Concerns about relapsing into substance use, suicidal ideation, a range of terrible harms that, again, is a product of colonialization and something that we need to stop and address, particularly as counsel who work with communities such as these. So in that case, I have this dilemma. I got to bring this case, probably seek an injunction right away, and 3 months is not a long time in the court process. And if I do that, there's no money. There's no civil society actor. I can't qualify for court challenges program because it's an Alberta case. It doesn't have that national dimension. There's no funder in Alberta. And in order for me, for instance, if I brought an advanced cost application in Alberta, in Edmonton, where Karey's case is, the next available date for a 2-hour hearing is right now, December 2022. If I want a full day, I'm looking at June 2023. It's not feasible. I can't get case management in Alberta anymore because of the court resources issues. And in order to kind of, if I had a commercial litigation case, if I was dealing with like a large commercial mortgage issue, I can get in court this week. For something like this, I can't get on the commercial list to be heard. So in that case, I just brought the application for an injunction. I had to rely on experts who do work for free, and on a quick turnaround, I had to work for free, which is normal in this sphere. But so from a practical perspective, like this mechanism doesn't really give us much. And to Karey's point, marshalling the evidence required to satisfy the court that my client is impecunious, it's probably easier for me relative to Karey's clients, but it's just, it doesn't reflect, I think, reality. And there's a vulnerability to these folks I represent from, former youth in care that are facing a variety of structural factors, but, often there is a substance use aspect towards it, where kind of capturing the full and thorough information that's required doesn't really reflect what we're working with here. There's a high degree of vulnerability, high degree of marginalization. And this doctrine, from my perspective, doesn't kind of acknowledge that, because I don't think the courts and the cases that have come before have been brought in those contexts, where it's highly marginalized and vulnerable people trying to assert their rights. And in that context, I don't know if there is a solution here. I think there is a system failure within our law. I think within our profession, within our kind of institutions, and the court in Anderson kind of highlights that. It talks about broader systemic reforms to this area of public interest litigation and funding that have to come from the legislative realm, not through courts developing doctrines. And I'm hopeful that we can have a broader conversation about that, because Anderson's a huge victory, but it's not going to help my clients. Even in the cases that I have done, where we're dealing with folks who are substance users, survival substance users, survival sex workers, the former children in care, even if we win in court, getting costs to be awarded on kind of something close to even a half a full indemnity basis is very rare. And maybe that's an Alberta thing, maybe that's just what we're dealing with here, but it makes it increasingly unlikely and difficult for lawyers to want to take on these important cases, to assert these significant pieces of litigation on behalf of often the most vulnerable people in our society. And when we're talking about advanced costs, in the environmental realm or in the realm where there's more institutional actors, I just hope we can have a broader conversation about, representing folks who can't fit within these frameworks, and where do we find the solutions to address this? With respect to the broader implications of this case, what was interesting, I think, is that I think if you were at the hearing or watched it, you'll get a sense that all members of the Supreme Court found an issue with what the Court of Appeal did. And I don't know if Karey would want to address this, but I will, that I think that the Court of Appeal decision was just so bad on its face that the Supreme Court of Canada was not going to maintain it. What it did provide, I think, for litigants, the Supreme Court of Canada case, well, even the Court of Appeal case, was an opportunity to clarify these aspects that were troubling lower courts, but also parties. Is, what record do you need? What questions do you need to hit, or should you need to hit to get this cost award, and as well as the broader pressing needs question for First Nations governments. I don't think it's narrow enough to just be something that First Nations or Indigenous nations can access. I think it's much, much broader than that. But I think it's likely limited in terms of being really helpful to institutional actors who have the opportunity to plan these pieces of litigation. And that's the thing that not bothers me, but I think is missing in this discourse or in the doctrine, is that sometimes you have cases that you can't plan. Like, you have someone who comes in today and I have to, launch something in weeks or, days often. And the work has to be done, notwithstanding that there's no money, and you have to figure out how to do that. And I think that's where the challenge lies. What do we have to assist in that, in those circumstances? And I don't think we have anything, to be frank. And it's going to be, we're going to have to continue to rely upon private bar lawyers, clinical lawyers maybe, who, if the work falls within their mandate, to just step up and do the work. And that's where I'm finding a lot of opportunity and hope that many lawyers across the country are willing to do that. That's all I kind of want to address. And if there are questions, I can jump into things a bit more. Thank you.
Thank you so much. Such a helpful zoom out to really think about the practical implications for a much wider subset of communities facing challenges around litigation. Okay, over to you, Professor Scott, to think about this in the Ontario context in particular.
Okay, thanks so much. And I really appreciate hearing from my fellow panelists too about this. And really all I want to do today is add a few comments that stem from my own experience working with a couple of different Indigenous communities that are facing disproportionate pollution burdens or engaging in land defense. And so the first example is the Aamjiwnaang First Nation, who brought an unsuccessful attempt at a protective costs order. Some people will remember in Lockridge versus the MOE in 2012. And I think Avnish wrote a law review paper about this while he was still in law school, if I'm remembering correctly.
With your help, Mr. Scott.
That was the Chemical Valley Charter Challenge. And so I'm going to just say a few things about that, in terms of reflecting on where this gets us. And then also, other communities that are facing extraction pressures or who are currently engaged in land defense. And this is, in my experience right now, from working with Nishnawtiga First Nation, which is in Ontario's boreal region. They refer to as the breathing lands, and Ontario refers to as the Ring of Fire. And in particular, I'm interested in the kind of dynamics around the impact benefit agreements or even resource revenue sharing deals, and what kind of incentives are put in place there, and what kind of openings, I guess, are available for communities that have already been forced into this, into the deals with the extractive companies that produce the revenues that might give them a slight leg up in terms of addressing those really pressing basic needs that Karey has spoken about, or, for example, maybe just even having enough staff members to engage in some of this strategic thinking and working with lawyers about what kind of litigation would be useful, versus communities that are trying to protect their homelands in this kind of more upstream way, right, from the extraction that would produce the impact benefit agreements. And can we have treaty litigation that's kind of upstream in that manner that can be used to prevent the violations or the threat of extinguishment? And so Nishnantika is also working with Raven Trust, and that was one of the things they were interested in terms of contrasting the different positions of these communities. So maybe I'll just say a couple of short things. One is that I really find the cost jurisprudence to be so centrally important, as like one of the major structural determinants of our legal architecture that we work with, right? And so that's, to me, that's broader than just thinking about it as an access to justice issue. And it's, you know, much more broadly the question of whether the legal system can ever do anything other than continue to retrench privilege, right? And even if we get the kinds of jurisprudence we want in these kinds of rulings, I think, as Avnish says, we still have to question whether litigation is ever going to be something that can work towards redistribution. So I always go back to my touchstone, Mark Galanter's classic critical legal studies piece from 1974, Why the Haves Come Out Ahead. Deep pockets and repeat players, right? And we really cannot underestimate the importance of that, I think, in figuring out what the outcomes are. So in the Aamjiwnaang situation, what we had was an application for a protective costs order, slightly different, of course. What they wanted here was not the upfront outlay of cash, as the court put it, but protection from an adverse cost award. And this is particularly important in that specific case where the application was being brought by two members of the nation, but not by the band itself. And one of the things the court found important in denying the protective cost order was both this idea that the case wasn't exceptional enough to merit that kind of award, some questioning of whether it actually raised issues of public importance, in part because of the fact that the case was brought by two members and not by the band overall, which I think all of us can realize now, especially, you know, in the wake of the Wet'suwet'en disputes and the 1492 land back lane. It's problematic for us to make that assumption that the band is always going to be available to get behind any litigation that has sort of public importance, right? Because of the contractual obligations that bands will have often now taken on with the companies whose permits are at stake in the larger litigation, et cetera. So I can answer more questions about the Aamjiwnaang situation if people are interested in that one. But then just to move on to Nishnantika. So people may know our Environmental Justice and Sustainability Clinic is working with Nishnantika. The litigation is now supported by the Raven Trust. Nishnantika is the kind of community, I think, that both Karey and Avnish have been speaking about in some ways. Very small, remote. They have a 27-year boil water advisory in effect. Certainly many similar struggles with adequate housing, suicide crises, and addiction. But the territory is largely intact, okay? So there have been lots of early exploration agreements and there's lots of mining pressure, but to the extent, or, you know, to the present day, that the territory is largely intact. And so that's a difference in terms of certainly are no major revenues from impact benefit agreements, and they have also opted out of the resource revenue sharing deals that the province has put on the table. And so in this kind of situation, you know, one of the things I really struggle with is like actual human resources and people's time, you know, whether people can actually have the time to put to the question of whether they want to engage in strategic litigation, right? The time to sit down with lawyers and figure out what that's going to mean, to even think ahead at all, as Karey said, like beyond the kind of putting out of fires on a day-to-day basis. And COVID certainly exacerbated that for the remote communities in Treaty 9. You know, so this is one of the things I want to think a little bit harder about. You know, there's certainly the case that Nishnawtika and many other Treaty 9 communities would love to have the opportunity to bring challenges to the interpretation of that treaty, right? They continue to believe they did not cede governing authority or ownership over resources in the territory. So those are obviously huge questions of massive public importance. But you know, we don't see that litigation, and so the question is whether advanced costs in some ways could ever go far enough to kind of tip the balance on that, I guess. And to me, the impact benefit agreements and the kind of extractive pressures puts another sort of spin on that, right? In the sense that you know, there's always money there to put towards community priorities from impact benefit agreements, but not towards litigation. And then the question is whether you can ever get enough traction, I think, against that kind of the grinding poverty that's produced by the state's failure to meet and, you know, basic obligations in order to kind of gain any ground. And I also want to think through, like, you know, in all of those cases, whether the impact benefit agreements are also taking away from the sort of longer term prospects for regaining governing authority and jurisdiction on the territory. And so, you know, it has this sense that we might be starting into a bit of a spin cycle on these questions, which kind of, you know, in some ways traps the nations further into that dilemma. So yeah, maybe I'll just leave it there, and I'm happy to answer any questions and talk further with folks about the broader dynamics.
Great. Thank you so much, Dayna, and to all three of you. So I want to open up the floor for questions. I don't know if while we wait for someone to be brave enough, if either of you three have anything you wanted to respond to each other with in terms of that. I don't know, Karey, if you have any thoughts on what your co-panelists said about these broader implications.
I mean, I agree that I think as I said too, but I think it's been expanded on by my fellow panelist about the articulation of the court is a little divorced from the reality for many highly marginalized and vulnerable groups. I mean, when I, you know, and I'm just trying to think again, like, it's really hard to talk about the level of poverty in a way that's sensitive to the real pain that people experience and not to normalize Indigenous poverty. And when I went into the community the last week again, and I hadn't seen folks for a couple of years because they were in lockdown from the pandemic, and it just was you know, overwhelming again, just to see the conditions that people are living in. And then you think about some of the demands that the Crown, which was accepted by the Supreme Court, and, you know, because I was arguing that level of scrutiny was unnecessary when it really was manifest that the nation's in poverty and they need some ability to govern without being expected to roll out some 5-year plan for how they're going to manage watching the youth in the community take their lives. Like, it's just it's really, you know, I don't even want to give examples because it's just really hard to do that on this forum without giving it the sensitivity and dignity that it deserves. But it does. But like I said, you know, we will do that, and hopefully the Crown will negotiate a resolution to costs. And if they don't, we'll have another decision from another court about whether the record that we've put together is satisfactory. But it does feel like the expectations what they need to show poverty is so divorced from what it is like to be in that level of poverty.
I think that connects to one of the questions that is laid out on the handout that Professor Lawrence so helpfully put together, which is really about kind of some of the lawyering ethics involved here. So, you know, Karey, at the beginning, you talked about reconciliation as part of your approach to practice. And I know that in the class, Professor Lawrence and I have raised at various points kind of some thinking about the ethical position of the Crown. So what here is the place of reconciliation in terms of the position that the Crown is taking in these kind of cases, and particularly here in these cases involving Indigenous claimants?
Well, I mean, I don't think reconciliation is driving the Crown's analysis at all. I don't even, in this case, I actually think the positions that were taken by the Crown were really dishonorable, and they were in many ways, it was in many ways, I felt like it was so aggressive. It was so adversarial. They never gave an interpretation that would benefit the nation. Everything that you could create doubt about, they would urge on the court an interpretation that was contrary to the First Nations position, to the point of it was ludicrous. Like, they would stand up and say, well, they didn't produce, they didn't produce all the salaries of all the employees. And they wanted us to know what the janitor was getting paid, what everyone was getting paid. And they would take the position that, which will all the financial statements, first of all, disclose what the salaries are, and then you can see how many people work in administration. But they would take a number, for example, of they would it's just so they would take a number that was not actually what they knew to be the accurate number of how many people work there, and then divide it by the total on the annual financial statements and propose that everyone in the community is making 100,000, and they know that that's not true. They know that. And so you have to stand up and correct them on that. Why are you doing that? Like, that is just, at least put the facts out honestly and have the court and say, like, we here's what the facts are. And so we think the test is this, and they think the test is that. But to spin the facts in a way that is intentionally seeking to make the nation look worse than it, and like another example in the Supreme Court of Canada hearing, I was saying that one of the funds was a consultation fund. There is some money that's put in there from contracts that people in the community do work, and it gets put in there. And so then, my argument was, it's dishonorable to ask the nation to use its consultation money to fund litigation. Like, that is not consistent with reconciliation in the honor of the Crown. It's an outrageous suggestion. And yet it was one that the Crown made. You choose. Do you want to consult or do you want to litigate? You got to choose that. And then even in the hearing, Justice Karakoustanis asked the other counsel for Alberta, is some of the money consultation? He's like, no, not all of it. And I'm like, come on, Aldo, 10% is not consultation related. Like, that. Don't leave the impression that it's just this big fund of just a fund of rainy day money. Like, that 90% of that money is directed to consultation activities. So you don't need, like, that kind of conduct, I think, is completely intolerable. And we have directives, there is that great directive that governs Crown Counsel for Canada on litigation. And it's not, I'm not seeing it. I don't know if my other panelists, but like, I saw some pretty offside things happening that I felt like we could have a fair debate about what the test should be, but don't try to spin the facts that aren't true. And leave a false impression. And say things like, I'll give you another example and then I'll stop ranting, but in the hearing that they were talking about the salaries, leaving these like ridiculous suggestions that people are getting overpaid, when that, again, I'm going to show how underpaid and overworked everyone is. But they would say things like, don't forget, to the court, tax-free. All the councils making 50,000 each, tax-free. And I just, what are you doing? Like, it's just baffling.
Thanks. I see Dayna's hand up, but also a lot of head nodding from you, Avnish. So we'll head first to Dayna and then over to you to wrap it up.
Oh, well, I just wanted to point out too, like a point we didn't talk about, but I see a lot of real willful blindness on the part of the courts when they're talking about this concern about the separation of powers, right? That this is so extraordinary because we would have to, the courts would be out overstepping the bounds. Because, when you think about so again, I'll use the Amjanang protective cost order example, but the court says something like, it would have the effect of undermining the usual incentive on the party to consider the prospects of success in making decisions related to the litigation. And they say again later, it cannot be in the public interest to pursue clearly groundless litigation that is doomed to fail. And yet, in the background set of the cost rules, we know that the parties with the superior resources are making strategic decisions based on how much money they have available to go forward, right? We've seen it with strategic litigation against public participation, the SLAP suits. We saw it in the motions that the company was bringing in that particular case, right? That they were doing it, despite the fact that there was not much ground to the motions, just because they had the money to do it and they had the superior resources. So then for the court to kind of come back and be like, oh, that would be improper if people, thought about the resources available when they were deciding their strategic, options. It just seems to me like that there's no questioning of those background rules, right? Like in whose favor do the background rules fall? And we're just going to hold them up and say, well, it has to be super extraordinary before we can go there.
Jump right in.
Yeah, one thing I would say is that, I think that what Karey is mentioning or describing is this, maybe it's the Alberta thing, but I don't think it is, but kind of a constant, aggressive, unending or unyielding kind of fight over these issues and this twerking of the facts to fit a particular narrative that sure, it doesn't reflect reconciliation or how courts should or how lawyers should, I think, approach issues in these areas, but it's just a fact of the litigation process in this realm. And I think the Court of Appeal decision, you see a court jump on that and accept that and kind of regurgitate that same sort of rhetoric. And there is, I want to imbue a realist take of litigation in this realm that, expecting the Crown or even the court to adhere towards what I think we all value in terms of commitment to reconciliation, being honest and fair, represent honest and fairly what is actually happening is not the case. And that's what makes often these cases so frustrating, is that there's a complete misrepresentation of facts and courts will accept it. And the harms are just so bad. I don't want to speak for Karey, but I feel it from you, Karey, is that it's not just what happened at the Court of Appeal and the position of the Crown, but the effects for the people you speak to day in and day out. And it just stays with you. And that's something law school does not prepare you for. How do you deal with that grief, right? How do you deal with that sense of responsibility? How do you deal with that loss? And yeah, it's good to win at the SCC though.
Moment to turn it back to Professor Lawrence with big thanks for all the work that she put into making this possible, because it's really been a fantastic conversation.
Yeah, I am so grateful to Karey and Avnish, especially for coming out and talking about the hard work that they do and what this work actually looks like. For those of you who are interested in kind of a lot of Avnish's caseload, I would say is outside the context of Section 35, and I think there's some really interesting and important questions to be asked there. If you follow his aging out of care litigation, one of the things that you'll see is that many of the folks who are involved in that, who are experiencing those harms, are people from Indigenous communities in Alberta. So we can also think about the links between these two contexts, even as our law continues to start to draw lines between a certain kind of litigation that's understood to involve Indigenous people and other kinds of litigation that maybe does not benefit from the same understanding of the litigation directive and when it gets applied. But I'm also very grateful for them not sugarcoating any part of this and making sure that we understand how limited this particular tool really is. And I hope that this can really be a part of, at this late stage in your first year of law school, for those of you who are in my class, and really thinking about what the possibilities actually are for achieving justice through public interest litigation. And I hope that, because you can see these very energetic and motivated and fantastic counsel doing this work, despite all the things, all the difficulties that it brings, that you'll stay motivated for that as well. So let me thank my colleagues for being interested in doing this. Let me thank my students for being here. And let me finally, again, thank Karey and Avnish for coming out and doing this with us. And I really look forward to further conversations about where this has gone and what is happening in Alberta and how different it is from Ontario, since Alberta exceptionalism is a constant question in constitutional law. We need to keep investigating that question. Thanks so much, everyone.